Picture two families sitting across from each other at the same kitchen table. Same town, same bank. One family lost a parent 3 weeks ago. They are grieving, exhausted, and buried under a stack of paperwork that makes no sense to them. The other family lost a parent 8 days ago. They are grieving too, but they are not buried. They walked into the bank on day 2, handed over a single piece of paper, and walked out with full access to every dollar their parent left behind. Same bank, same grief, completely different outcome. The only difference between those two families is a form. 1 page, no lawyer required, no court filing, no fee. And the overwhelming majority of Americans have never heard of it, never filed it, and have no idea that without it, the bank is legally required to freeze every account the moment they learn someone has died. That is not a bank policy. That is the law. And it does not care how long you have been a customer, how much money is in the account, or how urgent your situation is. The money stops moving the moment the death certificate arrives at the branch, and it does not start moving again until the legal system says so. For most families, that process takes months. Sometimes it takes years. And it costs money the deceased was probably trying to leave behind. Here is what almost nobody explains before it happens to you. There are roughly 3.5 million Americans who die every year. A significant share of them leave behind bank accounts with no beneficiary designation on file, no transfer on death form, no payable on death form, nothing that tells the bank where the money goes next. And when that happens, those accounts do not quietly pass to the family. They fall into probate, the legal process by which a court decides who gets what, at whatever pace the court feels like operating. The average probate case in America takes somewhere between 9 months and 2 years to resolve. In complicated estates, or in states with backlog courts, it can stretch longer. During that entire window, the money in those accounts is untouchable. Rent, utilities, medical bills, funeral costs, all of it comes due on its normal schedule. The court does not pause the calendar while it works. The form that prevents all of this is called a payable-on-death designation. Some banks call it a transfer-on-death form. The name varies slightly by institution. The function is identical. You walk into your bank, fill out a 1-page form naming a beneficiary, and from that moment forward, the account bypasses probate entirely when you die. No court, no waiting, no lawyer. The named beneficiary walks in with an ID and a death certificate and walks out with the money. That is the entire secret. 1 form, filed once, free at every bank in the country. Now here is where most people make the first mistake. They hear this and assume they already have it handled because they set up a joint account with a spouse or an adult child years ago. A joint account and a payable-on-death designation are not the same thing, and confusing them costs families every single year. A joint account gives a co-owner access while both people are alive. When one owner dies, the surviving owner typically does retain access, but there are complications. A joint account means that co-owner has legal rights to the money right now, today, while you are still living. If they go through a divorce, a bankruptcy, or a lawsuit, your money in that joint account is potentially exposed to their creditors. You did not intend that. The account did not warn you about it. It just happened. A payable-on-death designation names a beneficiary who has 0 access to the money while you are alive. The account is entirely yours. They cannot touch it, borrow against it, or put it at risk. When you die, it passes to them instantly, outside of probate, with no exposure to their financial problems in the meantime. Same end result as a joint account in the best case scenario. Substantially safer in every other scenario. Let me put a real number on what the wrong choice costs. Probate fees in the United States typically run between 3 and 8% of the total estate value. On a $200,000 estate, that is $6,000 to $16,000 in legal and court fees paid out of the money you worked your entire life to leave behind. In California, attorney fees for probate are set by statute, and can legally reach $13,150 on an estate of that size. In New York, fees are comparable. And that is before you account for the time your family spends navigating a system that was not designed for people who are also trying to grieve. There is a character I want you to picture. Call him Gerald. Gerald is 71 years old, a retired machinist from outside of Cleveland. Gerald is not wealthy by any standard measure, but he is careful. He paid off his house. He has $94,000 sitting in a checking account at the same community bank where he has been a customer since 1987. He has a will. He told his daughter Linda everything goes to her and her brother equally when he is gone. Gerald believes this is all handled. Gerald is wrong. A will does not override the probate process. A will is in fact a document that goes through probate. It is your instruction to the court about what you want. The court still has to review it, validate it, notify potential creditors, wait for objection periods to pass, and then distribute accordingly. Gerald's $94,000 will sit frozen in that community bank, completely inaccessible to Linda and her brother for however long that process takes. And Linda will be paying the funeral home, the outstanding utility bills, and the final medical expenses out of her own pocket while she waits. All of this disappears with a payable-on-death form. Gerald fills it out at his bank. He names Linda and her brother as co-beneficiaries with a 50-50 split. The bank keeps it on file. Gerald's will still exists. His wishes are still documented. But the bank account no longer waits for the court. The morning Linda brings in the death certificate, the money transfers. That afternoon, the funeral home gets paid. Here's the part that tends to surprise people the most. This form does not just apply to checking and savings accounts. In most states, you can attach a transfer-on-death designation to brokerage accounts, investment accounts, certificates of deposit, and even, in many states, vehicles and real property. The same principle extends across your entire financial life. The goal is to build a layer of direct transfers underneath your will so that the most important and most liquid assets move instantly, without waiting for a court to give them permission. The accounts that cannot carry a payable-on-death designation are retirement accounts like IRAs and 401ks. But here is the thing. Those accounts already have their own beneficiary designation system built in. When you open the account, you were likely asked to name a primary and contingent beneficiary. If you did it and kept it updated, those accounts also bypass probate automatically. If you did it 25 years ago and named an ex-spouse or a parent who has since passed away, the designation is outdated and potentially dangerous. Retirement accounts pass to the named beneficiary on file, regardless of what your will says. The will does not override it. The court does not override it. The name on the form is the name that gets the money. This is the detail that has torn families apart. A man updates his will after a second marriage, intending everything to go to his new wife. He never updates the beneficiary on his IRA. He dies. The IRA, which may represent the largest single asset in his estate, goes to his first wife. Legally, correctly, exactly as the form he filled out decades ago instructed. His current wife gets the house and the checking account. His ex-wife gets the retirement account worth 4 times as much. His lawyer told him his estate was in order. Technically, it was, just not the order he intended. The fix for this takes 11 minutes. Log into every retirement account you hold. Check the beneficiary designation on file. Confirm the name is current, the person is living, and the percentage allocations are what you actually intend. Do the same for life insurance policies, which operate on the same system. The named beneficiary collects directly, regardless of the will, regardless of family dynamics, regardless of what feels fair at the dinner table. Now let me walk you through exactly what to do this week, because the form itself is genuinely simple, and the bank will walk you through every line. Step 1. Call or visit every bank and credit union where you hold accounts. Ask specifically about adding a payable-on-death or transfer-on-death beneficiary to each account. This is a standard request. Any branch employee can process it. You do not need an appointment with a banker or a financial advisor. You do not need to bring anything other than your ID and the full legal name, date of birth, and social security number of the person or people you intend to name. Step 2. Name at least one contingent beneficiary alongside your primary. A contingent beneficiary inherits if your primary beneficiary dies before you do or simultaneously in an accident. Without a contingent, the account may still end up in probate if the primary is gone. One additional name on the form eliminates that gap entirely. Step 3. Review every retirement account and life insurance policy using the same framework. Log in or call the plan administrator. Request the current beneficiary designation form on file. Verify every name. Update anything that is outdated. Step 4. Write down where every account is, what institution holds it, and who you named as beneficiary on each one. Keep that document somewhere your family can find it. A safety deposit box your family cannot access after your death defeats the purpose. A sealed envelope in your home files, shared with one trusted person, is enough. Step 5. Set a reminder to review all of this every 3 years, or immediately after any major life event. A marriage, a divorce, the birth of a child, the death of a named beneficiary. Any of these should trigger an immediate review of every designation you have on file. Here is something the financial industry rarely explains cleanly. These designations are almost infinitely flexible. You can split an account among multiple beneficiaries in any percentage you choose. You can name a trust as beneficiary if your estate planning involves one. You can name a charity. You can structure the designations to reflect exactly what you want with a level of precision a simple will often cannot match. And unlike a will, these designations do not require an attorney to prepare, notarize, or file. The bank handles the paperwork. You provide the names. Think about what the alternative actually looks like in practice. The family that did not file the form. 2 adult children who love their parent deeply and are now sitting in a probate attorney's waiting room, paying $300 an hour to navigate a process that exists entirely because one form was never filled out. The grief does not pause for the appointments. The bills do not pause for the court dates. The siblings who were close before this are now under financial pressure and legal stress at the worst possible moment in their lives. Not because anyone was cruel or careless, because no one told them about the form before they needed it. That is what this is really about, not paperwork, not legal strategy. The ability to hand your family a gift that does not require them to fight for it. The money you saved, the account you built over decades of ordinary work, arriving in the hands you intended it for, on the timeline they needed, without a single court date in between. The Payable-on-Death form is not a sophisticated estate planning tool. It is the minimum. It is the floor. It costs nothing and takes less time than an oil change. And it is the difference between your family having access to what you left them and your family spending the next year of their lives asking a judge for permission to touch it. Gerald needs to go back to his bank this week, and so does almost everyone watching this. Because the form is free, the process is simple, and the cost of not filing it falls entirely on the people you are trying to protect. The bank will not call you and remind you. The court will not warn you ahead of time. The attorney who reviews your will may not ask about your account designations because that is not the document they were hired to review. Nobody is going to do this for you. And the people who pay the price when it does not get done are not you. They are the ones you love most. One form, one afternoon, filed once. That is the whole move.